welcome back to my resident viewers. And for those who don't know me, my name is Sheila Kololo, a double master's graduate, a junior forensic investigator, currently on secondment as a candidate attorney. And on this page, we are all about legal education. So whether you're a first year student, second, third, whatever, or just aspiring to join the legal career, please click the like and subscribe button. So yay, what are we doing for today? So today we are back because my fellow candidate attorneys are prepping for their board exams. So today we'll be dealing with the lead guide, unit 2 under action procedure, which deals with the content issue and service of someone. That is unit 3. I have done unit 2 previously, so if you have not watched that, please do. But today, we are doing with just summons and so these are on page 84 to page 94 of the lead guide. So whoever is preparing for their board exams, I'm gonna say this for the 100th time: the lead guide is what you need to pass your board exam, especially the theory. So you have no business in prioritizing buying notes here and there without you having consulted the lead guide. Please do not downplay yourself. The lead guide. All right, now let's get on to it. So our first topic that we're dealing with is the content of summons. What is supposed to be in a summons? So essentially, you are dealing with an instruction from a client. So whatever you put in your summons should be something that you were told by your client. So when drafting summons, you cannot assume facts on behalf of your client. You have to stick to what your client told you. In a nutshell, that's what goes into your summons. And then moving on, what we also have now is when can parties be joined in a matter. So it is a rule of law that whenever one has a direct and substantial interest in a matter, as well as the order that is to be granted by the court, then that person ought to be joined, right? So the court will never adjudicate a matter if there is a person that is supposed to be joined but has not been joined. So the court will then say, okay, fine, this person needs to be joined before the matter can proceed. Then that person would now have to be joined. In certain instances, there are certain parties and organization can request to be joined in a matter, although it is not compulsory that they do so. So you would see usually when, let's say, when an organization or joining as the friends of court, I know there's a Latin term for it, but we're no longer there. So yes, then they join the matter in as the friend of the court. So yeah, and then now we go on. There are types of joinders. We've got a joinder as a matter of convenience, as in a compulsory joinder. So a joinder as a matter of convenience is where the matter, you can join either or party. So there's A and B, you can join either A or B. So it doesn't matter. The court will still proceed and adjudicate. And then you find a compulsory joinder. A compulsory joinder then, it can't be an either and or. So it has to be a specific person, and until such a person has been joined, the matter cannot proceed in court. And then we've got a non-joinder and a misjoinder. So now, what is a non-joinder? A non-joinder is Sheila is supposed to be joined in this matter. It is compulsory because she's got a direct and substantial interest, but she was not joined. Then now we have to go back to the drawing board and call in Sheila to join in the matter. And then a misjoinder. A misjoinder then occurs in a situation whereby a party has been improperly joined in the matter, and they need not be there. So then that person can be removed. from being cited. And then we've got a situation whereby you have a right to waive a joinder. However, if you waiver your right to joinder, that does not mean that if the court grants a judgment, when you'll be excluded from it. No, it does not work like that. It is still binding on you, irrespective of the fact that when are you elected to waiver your right to be joined in the matter. And now coming to the specifics of joining plaintiffs. So when you join plaintiff in a matter, the claim is supposed to be the same and the relief sought is supposed to be the same, and also against the same defendant. Also goes for the defendant. It is supposed to be on the same question of law or fact with the same plaintiff. Then you can join the defendants, right? So yes, so that is it about joinders, guys, under our unit 3 of the lead guide. Sweet and short. And then now we are going to rule 17.4, which is the rule that now prescribes how we describe our parties in our pleadings. How do you describe a person? So guys, for example, I'm the plaintiff, you're drafting particulars of claim. How do you cite me? You're going to cite me like this. So rule 17 requires that the name, the surname, the gender, as well as the address of the person ought to be there, as well as, and also the occupation, right? So that is not limiting, but these are the 5 that should be there whenever you are describing your party in a pleading. So how would you then describe me? So if I'm a plaintiff, you're going to say the plaintiff is Sheila Kololo, an adult female employed as a lawyer, residing at, right? And then you put in my address. So and also you're going to put my ID number there. So ID number, you're obviously going to put it like in brackets. Yeah. And then you go now to if you now have to cite your defendant, same rule applies, but you can always add in a certain line in case there's something that you don't, like certain information that you don't know about the defendant. So then let's say you're citing the defendant and I'm the defendant in this case. You're going to say the defendant is Sheila Kololo, an adult female employed as residing at blah blah blah, whose full and further particulars are unknown to the plaintiff, right? You see, it's really that easy. And then if you are citing someone in their representative capacity, you are going to cite, let's say it's a minister, right? You're going to cite the minister in terms of which provision that he's empowered to act, and then you're going to say in his representative capacity, because we are not bringing the matter against the minister, but in his representative capacity as the principal head of whatever department or whatnot. So citing your parties, guys, is really easy. You should never struggle with this. If you do struggle, please refer to rule 17 of the Uniform Rules of Court. It is very helpful on how you cite your parties. And then now moving on to rule 18. So I'm not going to dwell much on rule 18, but what I'm going to tell you is that rule 18 is about drafting. So you do not go and just draft loosely without you having consulted this rule. You need to understand what rule 18 is all about in order for you to have like a checkbox that, okay, I know that my pleadings has to have a case number, has to have a court citation, the parties, the heading of the pleading, and as well as the closing, right? Because in an exam you get individual marks for all of these things. So unless they say omit heading and ending, you are supposed to include this in your pleading. So please, to master your drafting, make sure that you read rule 18 so that you know that in a pleading what are the key things that I'm supposed to have, like always whenever I draft my papers. Because I know some of us are not yet candidate attorneys. Maybe you're with law school and you do not do a lot of practical drafting, so you might only know that which you have been exposed to by law school. But please read rule 18 in terms of you knowing what goes into your drafts. And then now we go to our it's inducia. Guys, these Latin terms, it basically okay, so when we have issued simple or combined summons in the higher court, the defendant has 10 court days to serve their notice of intention to defend. And then in the case whereby the defendant is outside of the court's jurisdiction and the distance is over 150 kilometers, then they should serve within a month, 1 month. And then if it's outside the court's jurisdiction but less than 150, it is 2 weeks to serve the notice of intention to defend. And then in the case whereby simple or combined summons are served against an organ of state, we ought to give them not less than 20 days to respond to the combined summon, either with the notice of intention to defend. And then in the case of provisional sentence summon, the prescribed days is 10 days from the date of issue of the summons. So because we're dealing with the High Court, the registrar is the only one that must issue summons. A summons that is issued not by the registrar of that court, the relevant court division, such summons would be then considered null and void. And then now coming on to who signs the summons. So summons can be signed either by an advocate and an attorney, or where in the case of an attorney, it should be an attorney with right of appearance with the High Court. That's the standard rule. Lastly, we've got rule 4, which deals with the service of summons. So guys, please read this. It is generally easy. I'm just gonna highlight it briefly. Like, it talks about, okay, so when summons are issued against a minor, you have to serve the summons on either a guardian or curator or whatnot. When you're issuing summons against a person, you have to make sure that it's either at their place of residence or business, and such you are issuing them to someone who is above the age of 16. And then if it's a person's place of employment, you have to make sure that it's someone still above the age of 16 who also has authority on them. If it's a local authority, it has to either be a town clerk, a mayor, or any other member with authority that can receive same. And then if you are suing people jointly and severally liable, each service has to be effected on each of them receiving their own copies of the summons. So it's just really that, like, if it's a company, you have to issue it serve it. Sorry, I know, serve and issue. I use these phrases interchangeably, and I learned really that it's not really the same thing, but forgive me, you guys get the joke. But nonetheless, if you are serving summons on a business, you have to serve them on a responsible employee. And then if no employee wants to acknowledge receipt of same, you can affix it on the office door. So please, I know the issue of affixing has been dealt with last year. Just make sure that in terms of companies, it is still applicable. And so just go there and understand the different methods of service and how a service should be affected. And then lastly, once the sheriff has served the summons, a copy of the return has to be handed over to the attorney to say that this is the proof that we have served the summons. Lastly, our unique, not really different, but unique types of service. We've got edictal citation. So by edictal citation, you are in let's say you're suing someone and they're not in South Africa. So what you're going to do is you are going to make an application to court to serve by way of an edictal citation, because the person is outside of the Republic. And when you do so by edictal citation, you're also supposed to have a sworn translation. So let's say you are going to, it's in French. it's in France, and then you would also have to have a sworn translation of the language of the summons translated into the language where that is spoken in France. And then we've got substituted service. Substituted service, the person is here in the Republic, but we don't know where exactly in the Republic. So then what we're going to do is we're going to ask the court to say that, okay, can we serve by way of substituted service? I mean, the person is not going to be prejudiced in any way or have their right to privacy infringed when we serve this. Then we can serve maybe by Facebook, because we've got you on Facebook, we see you post, we can serve you on Facebook, Twitter, or whatnot. And then there's also a requirement that it has to be a notice has to be published on a local newspaper, that a substituted service would be made to the person. So yeah, that is all about it, guys, for today. Very sweet and short. Please, guys, now that we're done, please read the questions on page, I think it's page 94, if not 95 of the lead guide, the assessment right after this unit. Like, I've seen those questions come up in the exam, so please do those questions, practice them. By the time you sit in that exam hall, make sure that you've done each and every question in the lead guide. But otherwise, guys, that's it from me. I hope you enjoyed the session and found it helpful. And from me, your legal guardian, Sheila Kololo. Until next time, bye.